U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments so that I may answer your questions today. I have a great topic for you today, and it's what if you received a denial? So, what if you received a denial? What do you do then? So, nobody wants to get a denial, but yes, it does happen. And usually, where I see this happening is where individuals do this on their own. They don't expect the process to be so complex. They mess up somewhere along the way. And then, as a result of that, they get a denial. After a while, they get a denial. And so, even though it can be devastating because the denial usually comes after months, sometimes years of waiting, this may be able to be fixed. And it depends, this is where it really is going to be dependent on what your situation is, what was the reason for the denial. Some denials you can't come back from. I'm going to tell you how it is, and some denials just mean that there's no coming back. That's why it's important to invest in your process from the start and to make sure that you get the legal representation that you need to get through it and get it right the first time, because some denials do mean that you can't come back from that. However, there are some other types of denials where you may be able to go ahead and refile the application or even appeal the application, just depending on what you're looking at. So, are you looking at a petition versus an adjustment of status application? But if you're able to go ahead and refile it, then it means that you do have a shot at getting it right at the second time around. And I have represented clients who have experienced denials after trying to do it themselves. They have come to me and we have successfully gone through the process and we've gotten the situation fixed. But as I said before, don't try to say, okay, since I can always refile on denial, let me try this first. Let me try to save myself some money or save myself some extra time of contacting the attorney and do it myself. And then if it doesn't work the first time around, I'll go and get an attorney, because as I said before, that can be devastating and you may not get a second chance. And this is where, when I do get clients who have previous denials, we have to go through an extra step of reviewing what happened, reviewing the basis of the denial, making sure that the whatever the decision was, it's not going to negatively affect free filing or filing another type of petition. And so it still does add a level of complexity to an application process when there has already been a previous denial. So by all means, you want to avoid it. But if you do receive a denial, I don't want you to sit there, give up, throw your hands up in the air, and say that you don't have a right to, or you're not going to pursue some sort of solution, because there may very well be a solution here. And this is where it's very important to call and schedule a consultation so we can review your matter and then we can get it fixed. The cost of the consultation is $150 for up to 1 hour. This is well worth your time and money because, as I said before, you avoid mistakes. That's the number one priority here. And you will hear me repeat it over and over again. The number, because I have learned it through my clients or through people who have come to me for advice after the fact, that you don't want to make mistakes to begin with, because mistakes mean that you could possibly lose your chance at a future in the United States, lose your chance at gaining status in the United States. So the the first purpose of the consultation is to make sure you are doing everything right, taking the right actions, that you understand your process, you understand all your options, you understand your eligibility going forward, and when the right time is to file. And then also, if you have experienced a level of complexity in your case where you've now received a request for evidence, or if you've received multiple requests for evidence, your case is dragging on with no end in sight. And also you have received a notice of intent to deny, or a request for evidence. Those can be turned around. And if you've received a denial, though there may be an appeal, just depending on what type of application, because not all applications or petitions come with appeals. And sometimes it makes more sense, rather than to appeal, to just go ahead and refile. So that is going to be dependent, though, on what happened in your case. I'll give you an example. So, for example, suppose you were denied because you are inadmissible. Suppose you went through either you went through the petition process at the embassy, or you went through the adjustment of status application process here in the United States, and then you got to the interview and they found that you were inadmissible. There are certain waivers that are available, and the question would be, were you given that option to begin with? Did you understand that you can file for a waiver to get forgiveness for certain past offenses or indiscretions, like immigration violations? There are waivers available. So that's one situation that can be fixed with a waiver. Another is, say you're going through the marriage-based process and you got denied, or you received a notice of intent to deny, because I have turned those around as well. So I've turned where the USCIS has expressed doubts about the bona fides of the marriage, and they have expressed their intent to deny. And then after the clients hired me and I responded, they went ahead and turned it all the way around. So 180 degrees from a denial to an approval. So in cases like that, it can be turned around, based on a legal argument. Of course, when I respond based on what's in the law. I do present a legal argument, to sway the officer, and for the officer to understand that despite their doubts, the applicants do qualify. So go ahead, get in touch with me. That's where you're going to get to the bottom of what you're going through. So you can do that by going to the link in the profile. We have many individuals who schedule their own appointments. It's very convenient, and you're able to use the link in the profile to do that. You can also use the number. So in the title of this live, I did put the phone number there. So you can go ahead and put the phone number go ahead and call the phone number, and the scheduling coordinators will be more than happy to assist you. My phone number is they're all over my videos. So there's no way to miss it. So many different ways to get in touch, to schedule that appointment for us to talk about what your particular situation is. All right. So I now another thing I want to mention here is, right there with a denial is that question of whether you can refile with a different spouse. So suppose you were married previously and somehow it didn't work out. Can you refile with a different spouse? Yes, that is a possibility. Of course, the whether it's a good idea, or the timing, or how to go about it, how to approach it, is going to depend on what was involved. So do never go ahead and do anything without getting representation, because there is a level of complexity at that point, and you have to make sure you do it right. But it is absolutely possible to remarry and file another application. And I have represented clients who have gone through that. but keep in mind that this is scrutinized. These types of cases are scrutinized, and you're going to get a lot of questions. You want to make sure that you're covered. Thanks so much for the love. Now, before I move forward to questions, I just want to remind you that I'm here Mondays through Fridays around lunchtime, so noon, between noon and 12:30, to answer your questions. And also, I bring a topic for you. Go ahead and share the live, tell others about it, share it. I do post it, so you can always share it, save it on your favorites, like and subscribe on YouTube so that other people can start to understand that I'm here to provide information and also to answer questions. Keep in mind, though, that the questions I'm answering, they're not legal. This is not legal advice. It is not personalized legal advice. You want to make sure that to get personalized legal advice, you schedule the consultation. However, this is general information that can give you a lot of insight into your own situation. All right, so let me go ahead and answer some questions. I'm both on YouTube. I'm keeping an eye on the comments on YouTube, and I am keeping an eye on the chat on Instagram. So go ahead and put your questions. I'm scrolling through right now, and I already saw one. So let me go ahead. Okay, so my wife is a US citizen and we recently separated. I'm not sure if she filed the I-130 petition for me. Is there any way to find out if she had because refused to answer me and is being spiteful? So I'm sorry that you're going through this. Yes, we do go ahead and we do have what's called a FOIA request. Now, the I-130 truly belongs to the spouse. So the release of the I-130 petition, the decision is going to be limited. It may be heavily redacted. In some cases, there may be partial denials, but absolutely there are ways to find out whether there were previous filings involving you as the beneficiary, and that's through what we call a FOIA request, a Freedom of Information Act request. Go ahead, put those questions in the comments. I'm here to answer your questions. So I talked about the possibility of what are the possibilities in the case that you got a previous denial. And the possibilities do include either appealing the decision if it's not allowed to appeal, or it is something that doesn't really make any sense to appeal. There's always the option to refile as long as everything looks good in your record to do that. So when we get our clients and we're very thorough with our clients in regards to previous denials. We review those denials to make sure we properly advise our clients, and we review those previous denials through the FOIA request. So sometimes it's necessary to pull records more detailed than what our clients have, and our tool to do that is through a FOIA request. So we go ahead, we review, and then we advise. So we file asylum here when we came after 6 years, and we get PD here. So I want to know if we want to file for cancellation of removal. Is it possible? We have US citizen child, 10-year-old. We're here from 17 years. So cancellation of removal is usually a form of relief that's requested in removal proceedings. So you really have to be in removal proceedings to be able to apply or get the cancellation of removal. So sometimes it does put you between a rock and a hard place, because nobody wants to have to go through the stress of facing possible deportation to get to that relief. However, if you do have a good, it sounds like you have your ties to the U.S., strong ties. You've been here for a long time. I'm assuming based on what I'm seeing here, you may be law abiding. If you've paid your taxes, you have proof of your good moral character, then certainly that could be the case. But there's no way to tell you whether you would have a strong cancellation of removal defense or a way of asking for relief unless I know all your facts, all the facts involved, whether you are in current proceedings, because if you're not, then cancellation of removal would not necessarily be on the table unless you get to the point where you're going through proceedings. I would like to travel to the United States. I'm a hotelier. I'm 50 years old. Would you advise me how much do I need to work on that process approximately? So you would have to pay it sounds like you may just want to visit, and you'd have to apply for the visitor's visa at the embassy. So they do have a process where you have to submit the DS 160 and then schedule your interview and wait for your interview to attend. You do have to show strong ties to your home country. So there is an application fee for the visitor's visa. I don't have it on my head. I would have to look right now what the visitor's visa fee is. But you can always check the Department of State's website, and they give you all the fees there. All right. So let's see. I'm seeing more questions here, so I'm going to go ahead and answer. Keep those questions coming. If I had an I-130 approval from 2007 through my father, who is now deceased, can I continue filing on my own? So this is you may have relief. So there's what's called humanitarian reinstatement, but it's going to depend on the timing. So that was a long time ago, over 10 years ago. And so you would have to look at those factors, the length of time, and then at the time that it was approved, where were you? What was your situation? So go ahead and you can always schedule a consultation to determine. But the 2007 is quite a while away. Usually with the humanitarian reinstatement, it's on a case by case basis. But they would have to understand exactly why should you be warranted, or why should you get such favorable discretion to get humanitarian reinstatement. So it may be a long shot, but I would want to discuss more with you before coming to that conclusion. If my baby father has a criminal record, can he petition for a fiance visa? So, yes, a criminal record does not mean that a U.S. citizen cannot submit a petition for fiance visa. However, what kind of criminal record? If it is, so they have what's in place called the Adam Walsh Act, where they want to make sure, they still do want to ensure the safety of the immigrant who's coming in. And so if there are violent acts of domestic violence, then that could definitely mean that it could prevent the US citizen from petitioning. However, if, say, it's not related to any violence, or there's no minor, so no crimes against minors that are involved or involving minors, then they may very well be in the clear. So we would have to determine, and anytime it comes to anything criminal, any criminal record, it's very important to make sure that you get legal advice, because any kind of eligibility in immigration based on criminal offenses, it comes down to what's the criminal offense. Does it fall under any category that would prevent the petitioner or the immigrant from getting that immigration benefit? So a criminal record alone does not stop a US citizen from filing a fiance visa. However, if it does involve domestic violence or some level of violence, or involves an offense involving minors, then that could be a different story. This is where it's very important, though, to schedule your appointment and make sure you get proper legal advice, not just general information based on assumptions. What month and year VAWA are working on now? So you can always go to the USCIS and you can look at case processing times based on the service center. What is the estimated time you're seeing for the work and travel permit? So it's going to depend on what category you're applying under. So if it's marriage based, I'm seeing 3 to 6 months. If it's VAWA, I'm seeing 6 to 12 months. If it's employment based, I'm seeing 3 to 6 months. Estrian Danzel, if my daughter files for me when she's 21, does she also have to be the sponsor, or can my sister be the sponsor? So every petitioner is required to submit an affidavit of support. The affidavit of support, by the way, is a special form that's submitted to show that as a petitioner, you have the ability to financially support the immigrant that you're petitioning. If you're now, what they'll do is they'll look at the sponsor, the petitioner, and if she doesn't make enough, the next thing they're going to do is look for if you've submitted a co-sponsor. Through consular processing, what's the cost to file I-130 petition and the whole NVC fee? So, so it's 320, 535 right now. Fees are going up. I believe it's going to be in the 700s. Next month when fees go up. But 535 right now, and then once you get to the embassy or the National Visa Center, you're looking at about 445 total. All right. Can people still travel within the state after March if they don't have a green card? So with March, I'm not sure, yes. So I don't know if you're talking about the Real ID Act, but March, they should still be able, and I believe they extended the Real ID Act, which requires you to have certain features on your identification to travel with the ID. So if they don't have a green card, I still anticipate that people can travel, of course, with valid ID. All right. If I have all documents and supporting evidence for our marriage case, approximately how soon can I expect to get my work permit? So I'm seeing 6 to 12 months. What is you're married to a US, what if you're married to a US citizen, then find out he's still married to his first wife and do petition for her and is still in process 2 years now. And when confronted, he's saying he did not know. Go ahead and give me a call, because now he has committed a form of bigamy where he deceived you and went and married, had a previous wife, and pretended as if he didn't know anything about that. That is a basis, could be a basis to apply for VAWA on your own. So if you're experiencing this, go ahead, give us a call, and we can just go through the eligibility criteria to make sure you meet all the other requirements. But when an individual does this to you, where they deceive you, you think you're married, you think your marriage is valid, and then you find out otherwise, then you can apply for VAWA based on that. And that means that you can apply for your own work permit, your own permanent residence through adjustment of status. The spouse, and you said here it's a citizen. So go ahead, give us a call, and we can talk about it, and then possibly get started. We just want to make sure that you are eligible. But in cases like this, a lot of people don't know this, that if you're experiencing this, where you've been deceived by a spouse, you've been duped into getting married, and then the person was already married, that's a basis for VAWA. My VAWA case was submitted. What does your case is being actively reviewed mean? It just means it's probably at the bottom of a pile of an officer's desk somewhere. So it doesn't mean that they have your file open and you're gonna get your decision in a matter of minutes or days. I have seen this case is actively being reviewed, open for months and even up to a year. So it just means that they don't need anything from you right now, and they're reviewing what they have from you. My VAWA case was submitted on October 21, 2022. I got my receipt and did my biometrics between then and February. However, my biometrics, I was advised that they sent back my packet. So if you have an attorney, make sure you talk to the attorney about that. If they, because I'm not sure why that would be, and your attorney would have those answers. Because my son and I filing fee was submitted together, I was told my I-360 has the date for October. Does this mean everything starts over? So usually when you're filing an I-360 petition, it's just for you. So I'm not sure. So if you got scheduled for biometrics, it usually means that they accepted your case. I don't know if they sent back the VAWA, but usually all of that comes together because there's no adjustment of status without a petition involved. So if something got returned, then it's not filed until they accept it. When I check the case status, it keeps saying information is unavailable. So if you have an attorney, check with the attorney. If you don't, you need to get one. And you can always give me a call and we can talk about it. But check with your attorney. Your attorney is going to have the best information. If you already have one, if you don't, this is the time to make sure you have one. All right, keep putting those questions in the comments. I'm here to answer your questions, so put your questions in the comments. Before I head out, I want to make sure that I've gone through all of your questions. All right, so I'm going to go ahead and just tell you how to get in touch with me once again. So go ahead and you can call the number. The number is in the title of the live. It's also on all my videos. If you go to the profile link, you will see a way to schedule your own consultation. You'll see a way to go to the website. On the website, you have a contact form that where we contact you. You have the phone number, you have the online chat. All three of those lead to a scheduling coordinator who will be more than happy to assist you. Now, if you don't want to go through that, you just want to schedule, go to the link, and there's a button for you to schedule your consultation. It carries you through an easy form where you can confirm your consultation. So go ahead and take those steps. I will be back tomorrow where I will come with a topic and you can come with your questions again, and I will go through and address those questions. Thanks so much for your time, everyone. And remember to share the live, let people know that I do come on every Monday to Friday around lunchtime to take your questions on Instagram and YouTube. Subscribe where you can so we can share this information together. Thanks so much for the follows. I appreciate it, and I'll see you tomorrow. Have a good one. Bye.